So we're going to spend the next 90 minutes talking about a really important topic, environmental justice. And this is a really important year to be reflecting on the environmental justice movement, because not only is it the 20th anniversary of really the seminal executive order on environmental justice that President Clinton signed into effect, but it's also the 50th anniversary of the Civil Rights Act. And so really an important time to take stock and to ask hard questions. Why is it that still poor and often minority communities disproportionately bear the impact of pollution, have worse access to clean air, safe water to drink, bear disproportionately negative health impacts like asthma? But we're also going to be thinking positively and asking what steps have been taken and ways that different agencies, whether they're nonprofit groups, governments, academics, corporations, are really trying to tackle this problem. And it's really a pleasure to be up here with a fantastic panel. First, we have Daria Neal of the Civil Rights Division at the Department of Justice, where she serves as the Deputy Chief of Federal Coordination and Compliance. But she comes to that job actually with a wealth of experience in environmental justice, having served with the Lawyers Committee for Civil Rights and authored some very seminal national reports on the topic that she's going to be sharing with us. Next, we have Sue Brigham, who is really a national leader on environmental justice, but come from the corporate perspective. As the Vice President of Federal Public Affairs at Waste Management, she's responsible for the DC office, for public policy, and also all the sustainability reporting. But she's also served on the National Environmental Justice Advisory Council, on several EPA advisory committees on Superfund sites. So is going to be, we're going to be grappling with some questions, which is how does the corporate community actually think about these issues? Next, we have Patrice Sims, an associate professor at Howard Law School. And he joined Howard after serving as an Obama appointee at the U.S. Department of Justice, where he was the Deputy Assistant General of the Environment and Natural Resources Program, and previously worked both with the EPA and with the Natural Resource Defense Council, and so brings a wealth of experience, having been in the trenches and thinking about it from the perspective of the government. And finally, we have Shanna Cleveland, who is a senior attorney at the Conservation Law Foundation, where she works with vulnerable communities in New England, litigating against coal power plants and advocating for clean energy. And for those of us in Boston, it is a great pleasure to have her, and she was recently recognized by the Boston Lawyer Chapter ACS organization for her efforts. And I should say that I am Sharmila Murthy. I'm an assistant professor at Suffolk University Law School in Boston. So first, a couple of administrative things before we launch into our panel. First, we actually just wanted to do a little poll, because one of the challenges when thinking about having a conversation amongst such a distinguished group of panelists is we want to make sure that we are engaging in a conversation with you and not speaking below or too high, not getting into jargon if that's not jargon you're familiar with. So could we just have perhaps a show of hands? How many people think that, feel that they know a lot about environmental justice and are very familiar with the laws that we might be talking about? Show of hands. Okay, well that's helpful. And that's helpful because one of my jobs too is that if we start dropping into acronyms and jargon, part of my job will be to actually dial it back and say, okay, let's put this in plain English so that we all understand. So that's great that so many of you are here to also learn about this critically important topic. For those of you that are looking for CLE, this is a seminar that you can get CLE for. And so you need to sign the attendance sheet, pick up their certificate of attendance, fill out an evaluation form, and there's folks, volunteers that can help give you more information about that. If you have a cell phone, we'd love it for you to turn it off or put it on silent mode so that we don't get interrupted. Our plan is to really try and have a conversation amongst ourselves for about 55 to 60 minutes, and then for the last half an hour, we're going to open it up to you. There will be a microphone going around, and we look forward to engaging with you at that point. So let's kick it off. Daria, let's start with you. So you come to the topic of environmental justice from a few different perspectives. You're now at Civil Rights Division at DOJ. You previously were at the Lawyers Committee for Civil Rights. And in particular, you have authored some seminal reports on environmental justice. So could you actually provide us with a brief overview of the history of the environmental justice movement and what that term even really means?
Right. No, thank you. And I'm really excited to see so many people here interested in environmental justice who don't know much about it. So I think your question to give an overview is really appropriate. Because the environmental justice movement, environmental justice itself, is something that's very distinct from what I think most people have come to understand environmentalism to mean. And the environmental justice movement is one that really came about in the 70s and the 80s from the civil rights movement, organized labor, and to a lesser extent, the traditional environmental movement. It was about the belief that communities of color were bearing their unfair burden, a disproportionate burden of environmental threats in their communities, and that the traditional environmental movement was not addressing environmental threats to their communities. The way that EJ advocates, EJ communities think about their environment is a lot different, I think, than traditional environmental organizations term the environment. It's the place where we live, where we play, eat, work, worship. So it's our living environment and things that impact our homes, our playgrounds, where our children go to school. We want everyone to be able to live in safe, healthy communities. And so that's how the environment is defined, different than when I was growing up thinking about environmentalism and water conservation and saving the polar bears and the redwood trees in California. This is very personal, I think, to everyone, because it's where you live every day. And to be able to have not just safe drinking water, but to be able to send your kids to school and not have flares from an oil refinery half a block away. The real activism really, I think, came about with a couple of cases and a significant protest event in the South. The first case was a case called Bean versus Southwestern Waste Management Corporation. And this case was brought in 1979 by a community in East Houston that believed that the siting of a landfill in their community was done intentionally because the community was African American. And they brought this case in court, and they lost. The court found that they were not able to provide sufficient statistical data to show that they bore a disproportionate burden of landfills in their community compared to others. That despite the negative impacts of having a landfill in your community, wow, a minute already? Okay. That they hadn't provided enough evidence, and so it failed. But another case out of Florida in which an African American community alleged that they were not being provided basic municipal services because they were African American actually succeeded. They were able to demonstrate that because they lived in a predominantly African American community, it was highly segregated, and the services that were being provided were provided predominantly to the white community. So that was a more successful litigation. I can't close without mentioning probably the most important activist event in environmental justice history, which was out of Warren County, North Carolina, where Warren County was selected, this community was selected for the siting of a polychlorinated biphenyl landfill, PCB, landfill, and the residents said, we don't want this in our community, and they protested. They stood in front of tractors and trailers that were coming in Over 500 people were arrested. And as a result of that activism, there began to be nationwide attention to the issue of environmental justice and burdens on minority communities. And there have been numerous reports, long before I got involved in this work, Toxic Waste and Race, which was issued in 1987, and 20 years later, Toxic Waste and Race at 20. The first report found that 3 out of 4 hazardous waste facilities were located in predominantly minority communities in this country. And the report that came out 20 years later found that not much had changed since. So to your point of where are we today, we've come, I think, a long way in awareness. The Executive Order 12898, I think, is critical in engaging the federal government in looking at what policies and practices it engages in that could have an impact, a disproportionate adverse environmental and human health impact on communities of color and low-income communities. And you've seen increased activism, I think, at the grassroots level and support by foundations and other organizations to ensure that we try to address those disparities.
Great. Thank you so much, Daria. So this is a national topic, but it is one that affects individuals in their communities. And I think that really trying to bring us down to the local level and thinking about what is it like working day to day with communities who are suffering from those health impacts, living near power plants. I'm going to turn it over to Shanna, who can speak about this, having served as a senior attorney at the Conservation Law Foundation for many years and is really in the trenches working with these communities.
Sure. And just to go back to what Daria was talking about with the Warren County protests that occurred back in the 80s, people were literally laying their bodies down in front of trucks and tractor trailers. I mean, that's what we're talking about was happening at that place. And what that reminds me of is recently I was in an agency hearing where a 20-year-old woman stood up and said, "Why should I respect your laws and protect your laws if your laws don't protect me?" And so that's one of the things that we're really dealing with here. And you know, sitting in a room like this with a group like this and talking about environmental justice is a little bit difficult because we live in a very rarefied place, the folks who are in this room. And we all come from different backgrounds, but the law has worked for us. And we're here because the laws have worked for us. And within, you know, the first or second semester of law school, you start to understand how the law works, how the administrative processes work. It starts to make sense to you, the way that these processes are built. But imagine living in a town of about 18,000 people, where 2 out of only 4 coal-fired power plants in the state are located. One of those coal-fired power plants is the largest fossil fuel-fired power plant in all of New England. And both of those plants have been located in your tiny town. Now also imagine that the law is not something that you've ever spent much time on. I mean, to a lot of the folks who are living in this community, the law is something that only comes into play, you know, if there's something bad happening, if there's a crime that's taken place. They're not involved in civil matters very often. They're never going before administrative agencies. They don't understand these processes. And you hear that one of the power plants that's been there since 1925 is about to be repowered to provide a new kind of coal-fired power called coal gasification, plasma gasification, and it's right across the street from you. And you hear this from a neighbor. Now, how many of you actually read the legal notices in your local newspaper? Anybody? Yeah. How many of you read the legal notices in your, you know, the biggest newspaper of circulation? I mean, nobody does. But that's where people provide notice that there's going to be a public hearing about a plant like that that's going to operate for 40 or 50 or 60 years. And so the first issue is people don't know that these facilities are about to be sited in their areas. Well, then let's say that maybe you did end up actually hearing about the public hearing that's going to be held. So you show up at your public library You don't know what to expect. You didn't know that you could have gone and reviewed the 600-page application that has, by the way, been refined over the course of about a year and a half in private meetings between the developer and the Department of Environmental Protection so that they could work out any issues that they had. You had no idea that was going on. And so you show up at the hearing and you find out you could have had an opportunity to speak, but you don't really know what to say because you didn't know you could have gone and looked at these documents. You're not an engineer. You don't know any engineers. You don't know any lawyers. And you don't like what you hear about the pollution that's going to continue to come out of this power plant. Well, that's the situation that I walked into when I started at Conservation Law Foundation down in Somerset, Massachusetts. There was this proposal to take a plant that had already been committed by their air permits to shut down in 2010, decided that instead they were going to repower it and go for another 50 or 60 years. And I was invited into people's homes, into their living rooms, and had the chance to sit down with them and try to explain to them what the process was for them to move forward and how they could try to change things. And one of the biggest issues I think that we face, and I'll try to stop after this, is that people who aren't used to this type of Byzantine regime see these projects as inevitable. And they really don't see what difference they can make. And so it's really important to have people who are able to come in and explain the process, provide them with the opportunity to understand what the proposals are, what their rights are, and not just give them process, because one of the issues that you'll often hear about when we talk about environmental justice and the environmental justice executive order and the use of Title VI is that you get process, but often that process doesn't amount to a result that you were looking for. And so I almost feel like when we take the time to bring people in and explain to them about all this wonderful process that they're going to get, and then they see that nothing results from that, that does a lot of damage to the credibility that people are trying to build around these processes. And so that's a little bit of a scene from the local level.
Great. So one thing that really struck out for me of what Shanna just said is this idea of a Byzantine regime, and that the laws and the processes that make up our environmental, regulatory, and legal system is very complicated. So we're now going to turn it over to Patrice to help us simplify this in a few minutes, distill down. So, prior to joining the Howard Law faculty, you served as a Deputy Assistant General in the Department of Justice's Environment and Natural Resources Program. You've worked at the EPA. You've seen this from the inside. So in a few minutes, can you try to give us the landscape? What are some of the key laws that we're thinking about?
Yeah, okay. I'll do my best. No promises. Shanna, I hope we get to come back soon
we will.
To this level, because I think this is where the important conversation happens at the community level. But it's also important to understand the bigger structure, the macro structure within which all of this is happening. I want to do just really quickly a little bit more polling. How many of you deal with federal environmental statutes on a regular basis? I think probably a few more of you, but still not a lot. Okay, good. So I'm gonna try to impress upon you how absolutely crucial these federal environmental laws are, and the agencies, in many instances EPA, but not always EPA. There are other federal agencies that are dealing with these statutes. Their administration of these statutes is also critically important, right? So I want to walk through a few and just give you a sense of what they do and why they're so important. So one, and this is the statute that I've worked on for most of my career, is the Clean Air Act. All right, the Clean Air Act is absolutely essential for the health of the people in our nation. Right? The Clean Air Act deals with a number of different things. It deals with what we refer to as criteria air pollutants. These are the things that you all may have heard of: smog. Right, when you see that brown haze sitting over Chicago as you're flying into O'Hare, right? That's smog. That's those O3 molecules, right? 3 oxygen molecules. Nasty stuff causes irritation, respiratory irritation and other things. Particulate matter, that's the soot, the small particles that are in the air, really bad for respiratory system and your heart. and a few other things, volatile organic compounds and some other things. But these are criteria of air pollutants. They're pretty much everywhere. They're emitted by all kinds of different things. A whole suite of stationary sources and mobile sources of all different kinds, planes, trains, buses, cars, all of those things, right? So the Clean Air Act covers those, which means that anywhere that there are sources of those types of pollutants, they're subject to regulation by EPA, typically under the Clean Air Act. It also regulates hazardous air pollutants. Hazardous air pollutants really important from an environmental justice standpoint because these tend to be the carcinogens, the mutagens, right, the neurotoxins that are emitted often from smaller facilities that are located right next to or sometimes right in the middle of a residential community. And these range from facilities that are as small as a dry cleaner to as big as an oil refinery, right? And those tend to have more localized impact, where smog tends to affect large areas, an entire airshed, as we call it in the Clean Air Act world. Hazardous air pollutants tend to have their most dramatic impact in immediate proximity to the discharge point. So Clean Air Act, really, really important. It sets the stage for these local processes around participation in the administrative process, right? And that participation happens both at the rulemaking stage, where the agency's looking at the statute, interpreting what it means, and saying, okay, here's how we're going to implement this statutory program, and they make decisions in that implementation process that can make that program either absolutely toothless or really, really, really protective, right? And the participation of people who care about that, and it really matters, right? And we'll get back into that conversation, I hope, in a little bit. So a couple of other things. The Resource Conservation and Recovery Act, what we all refer to as RCRA, right, regulates hazardous waste disposal and non-hazardous waste disposal. And there are a suite of reasons why this is really important and how it affects communities in a variety of ways. Clean Water Act regulates discharges into surface waters. It also regulates through the Oil Pollution Act things like oil spills that tend to impact communities pretty dramatically. Something that we don't hear enough about, I think, is something called that regulates pesticides. Pesticides that affect us because they're on our food, but even more importantly, affect communities that are involved in the agricultural activities and that live and work and play and go to school near those agricultural centers, right? Pesticides really important. Other side of pesticides is poisons for things like rats. We had a very important case I worked on back at NRDC, a rat poison case that was really significant in terms of how it affects people, typically low-income and minority people who tend to get disproportionately poisoned by rat poison. Anyway, I'll stop there. One other thing to mention, disclosure statutes, very, very important. This gets to this question of how do you know what's going on? How do you know what's there? And that includes things like the National Environmental Policy Act, NEPA, and EPCRA, which is a community right to know, which tells you in your community if there's a facility that has lots of toxic chemicals.
Great. And so part of what we're trying to do is, before delve into these really important critical issues that have been raised, is to actually just create the landscape. Who are all the different players? What are all the, so we've thought about this, the national environmental justice movement, coming down to communities and the way that they experience interacting with the system, even if they are on a daily basis exposed to pollution, to this macro level of the different laws. We're going to turn it over to Sue Brigham, who, as the Vice President for Federal Public Affairs at Waste Management, has been very involved in environmental justice issues, but frankly because Waste Management, as its business operations, has to be dealing with these issues on a daily basis. Where are you going to be siting your facilities? And if you think about how in some ways mundane this is, right? We all have garbage that we produce every day, solid waste, and Waste Management is an organization that is in many ways helping us deal with that, but at the same time, there are sometimes impacts that communities experience. So Sue, if you could sort of share with us that industry perspective, how are you advising your clients about this issue?
Sure, and I'd like to pick up where Daria left off, because I think that the next step in the story is really interesting. Oddly enough, I think I'm incredibly lucky to work for Waste Management. We provide an essential sanitary service, but we are also, after all, waste is what you throw away, discard, highly unpopular. So when the study by the United Church of Christ, Toxics and Race, came out in the mid-'80s and said that hazardous waste facilities were cited in a discriminatory fashion, everybody at the company was shell-shocked. And I mean from the board of directors on down. This kind of accusation is about as profound and disturbing as you could find. And the good thing is that it made us realize we obviously are missing the boat if we're not really engaging on this issue so we can understand it and we can see how can we be seen as a constructive player. Compliance, 100% compliance, is the foundation and the expectation and demand on every single corporation that regulates, one of the profoundest obligations of the federal government. But I don't see EJ as compliance. I see as going beyond compliance. And that was one of the good opportunities, because we came to see that as we talk kind of in policy discussions in DC and state environmental justice work groups and commissions and conferences, and then we saw that we really needed to be engaging very deeply with the communities in which we operate, because it doesn't do any good to sit back and say, we're following all the rules. If a community says we have the following concern, we have to figure out a way to address it and to make us welcome and perceived to the maximum extent we can as a good neighbor. So interestingly enough, when the second version of Toxics and Race came out, we decided, you know what? We're not going to quibble about anybody's definitions anymore. We're going to simply embrace the fact that the pattern of a facility siting, even if they comply with zoning and everything else, is a subject the public has a right to know about. And so we adopted the protocols in the book. The EPA uses them now. We found out that for our company, our impression was correct. In fact, we are predominantly located in kind of middle-income white communities. But we also by then knew that that didn't matter, because it didn't matter what the overall was. It meant that every time someone raised an issue, it was still extremely important to us. And so we continued to support these kinds of dialogues, because we realized we never really kind of know enough about what the new concern the communities will have and how we can make sure we're going to address it positively.
Great. Thanks so much, Sue, for offering us that perspective and an example of a corporate entity really trying to be at the forefront of the issues. But Shanna, let's come back to you. You know, we have here perhaps an example of good corporate social responsibility, thinking about going beyond compliance, but you're working with communities that maybe aren't, that are really facing the brunt of this. Could you pick up your story and share with us some of the ways that you're trying to use litigation to hold power companies and others to account?
Sure, and it's interesting. Sue and I were talking before the panel about the fact that I'm here instead of another person at Conservation Law Foundation who runs our Healthy Communities and Environmental Justice program, and her name's Veronica Eady, and she has been very much a part of the environmental justice movement. And what's interesting is that at CLF, before Veronica came on board and over time, CLF had kind of viewed the current environmental justice policies and methods of litigation as not being very effective because they did provide this process, but there wasn't necessarily a lot of substantive bite to those policies. And so the work that I ended up doing was based entirely on the Clean Air Act and the citizen suit provisions of the Clean Air Act. And so in this case where we had a coal-fired power plant that was being proposed to be modified so that it could run on this new type of technology, what we did was go in, meet with people in the community, talk to them about what their experience had been with the company thus far, and what they thought about the fact that it was going to be continuing now, this plant that had been around since 1925. And what we found was that a lot of folks who lived, and this is a power plant that was literally across the street from a residential neighborhood and about 3 blocks down from a school and school playgrounds. So this was something that was cited in 1925. People weren't really concerned about air pollution in 1925, and some of these facilities are in places that you would never put them today. But so what we did was we took a look at the Clean Air Act and what was provided for under the Clean Air Act, and we challenged the permitting decisions of the agencies based on the failure to meet the requirements under the Clean Air Act. And the first issue that came up, you might guess what the first issue that came up when we raised our appeal was? Anyone? Come on. Standing. Standing. So basically what the Department of Environmental Protection said to these people who lived literally across the street from this coal-fired power plant and who cleaned coal dust off of their windowsills and clotheslines on a weekly basis was that because it was a widespread harm, a generalized harm, they did not have a particularized injury that warranted standing. And they went farther in this case. They actually said, when you're looking at a state permit being issued by the DEP, even though it's being issued pursuant to the Clean Air Act, the only person who has the right to appeal that permitting decision is the applicant, because that's the only person whose rights and duties are being determined in that proceeding. So that's what we were up against, even using the Clean Air Act. And what's interesting about this case is we ended up, the facility shut down, but we didn't win that case outright. We fought that case in an administrative appeal. We lost before the Department of Environmental Protection because their own presiding officer made the ruling about whether or not they had followed the proper procedure. We lost in front of the commissioner because that's then who looks at whether or not the hearing officer made the appropriate answer. We went to Superior Court, and we actually won in part in Superior Court. And so that resulted in enough of a delay in the project that they ended up scrapping the project because, frankly, it was an experimental technology that wasn't a well thought out project to begin with. But that's not how you want to win these cases. And we certainly wouldn't have taken on the case but for the fact that we felt that there were clear substantive violations that had occurred in the issuance of that permit. But because of the issues around standing, it was a case that was won over delay rather than over getting a substantive result that the community could feel good about and made them feel good about the system.
Yeah, and I think this point about standing is so critical. I mean, when you just think about where we are today at the American Constitution Society, I mean, this critical issue of a progressive vision ties so directly to this question of standing. I want to turn back to Daria to perhaps share some experiences from your current role at Civil Rights, DOJ, and in that capacity, you're working to ensure uniform compliance with Civil Rights Acts among federal agencies and agencies receiving federal funding, which in many ways, given the attack on standing, just shows that that is such a critical point. And I know that there have recently been some important cases, and I wonder if you could share one of them with us.
Right. You know, Title VI of the Civil Rights Act has been the main civil rights tool that communities have used. And just by way of background, Title VI specifically states that no person in the United States on the grounds of race, color, or national origin shall be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity that receives federal financial assistance. Agencies also issue regulations to implement Title VI of the Civil Rights Act, and their regulations prohibit the development of criteria or methods that may have discriminatory impacts or effects based on race, color, or national origin. And the reason why we look at the civil rights laws and Title VI in particular is kind of going back to these reports. I mean, these reports found that while race and income could be determinative of whether one lives near a toxic facility, a hazardous waste facility, race was by far the main determining indicator. Income came second, but it was far behind race. And so as communities try to deal with adverse environmental threats in communities of color, what they don't want lost is the fact that many of these decisions are race-based or have racialized effects. And so they look to statutes like Title VI. Agencies are responsible, agencies that provide federal financial assistance are responsible for enforcing the statute. Individuals and communities can bring complaints to those agencies, but it's the agency itself that investigates and tries to resolve the issues raised in the complaint. So I'll highlight, if time permits me, two, but one more recent matter that has gotten a lot of attention by transit equity advocates. As I mentioned earlier, the environment is everywhere where we are, and transit is part of that. A community filed a complaint, a Title VI civil rights complaint with the Federal Transit Administration, alleging that the city of Beaver Creek, Ohio, had discriminated against minority transit riders when it failed to approve the development of additional bus stops. So why is that significant? So in Dayton, there was, the Regional Transit Authority manages the transit system, and buses would go from Dayton up to a certain point, and at one point the route would stop. Well, where this route stopped, approximately 1.5 miles away, there was a mall, a shopping center that included not just shops, but medical services, an educational service like a DeVry type of university, and lots of different services that people could avail themselves of. For people in Dayton to be able to get from the end of the stop to those services, they had to walk 1.5 miles, cross over a 6-lane expressway, cross over roads that didn't have sidewalks in order to benefit from those services. The proposal from the Regional Transit Authority was to develop 6 new bus stops that would go through the city of Beaver Creek, and Beaver Creek had to approve those. Beaver Creek did not, for a variety of neutral reasons. One, they were concerned about safety. Would it be safe for the development of these new stops? If these stops were to be placed along this route, the Regional Transit Authority was to provide some additional, was to comply with some additional criteria, which included each stop being air conditioned and heated. The stops having police call boxes in each of them. The pads for where people are supposed to stand, the cement distance, which was normally, I think, 10 inches, was to be 18 inches. So these criteria, one, were beyond what even the local ordinances required, but were clearly put in place to discourage people from being able to effectively transport themselves from one part of town to obtain benefits in another. FTA investigated, Federal Transit Administration, investigated the complaint. They walked the route, met with the complainants, and in the end made a finding that, in fact, the city of Beaver Creek had violated Title VI of the Civil Rights Act, and they worked with the city to try to resolve the issues raised in the complaint and add some additional bus stops. So that's just one example. There are many recent, and when we talk about, I think we're going to talk about public participation, I can share a little bit more about some recent activity at EPA.
Great. Yeah, so we are trying to move across issues, and I think participation is a theme that has cut across. I want to turn it back, though, to Patrice. We've thought a little bit about enforcement of Title VI. Let's come back, though, to the EPA. And having worked at the EPA, I know that you have a sense that the agency could, in fact, be doing more from the inside. And I wonder if you could share a few thoughts about that before we come back to the public participation question.
Yeah, okay, well, let's, so there's a couple of issues with the federal agencies and EPA in particular in terms of the degree to which their programs and so I'll look separately at programs of implementation and administration of their environmental statutes, and on the other side, enforcement of those environmental statutes, which EPA is largely responsible for, and in many instances with the assistance of the Department of Justice when they're litigating those cases in federal court. So, what's going on? I mean, why doesn't the agency automatically recognize that, hey, here are communities that are subject to serious, life-threatening, in many instances, impacts from pollution, and as Shanna was saying, are in most instances not in a position to effectively advocate on their own behalf, right? I mean, these administrative processes are complicated, whether in the administration of the laws, the implementation of the laws, or the enforcement of the laws context, right? And so why isn't the agency already recognizing that and saying, well, look, part of our job ought to be making sure that how we're taking care of these statutes, how we're implementing and enforcing these statutes, making sure that what that does is protect to those people who are most vulnerable to the pollution that is the target of these regulatory programs. Well, there are a couple of answers to that, I think. The first of those answers will not surprise you, right? The first of those answers is right here. Right? Where's the money? Right? There are, I mean, if there's a number of sources you can go to look at this, and none of you will find this particularly surprising, but industry spends hundreds of millions of dollars every year advocating around environmental policy, both new environmental policy and the implementation of existing environmental policy, right? They have the capacity to hire experts, to submit reams and reams of material in every rulemaking and every permit proceeding, right? And to really make that process put weight on the scale on one side of that process, right? And the communities, as Shanna was pointing out, can't do, even when they find out that it's happening, right? Even when they show up, they don't know what to bring. They can't hire experts. They're not making the arguments that are going to be the effective arguments. And so one of the things that's troubling, even when you look at EPA's efforts to address environmental justice, those efforts over the last decade and a half have been mostly procedural. How do we have more public hearings in more communities? Well, you know what? It doesn't help all that much. Because what are those public hearings? You show up, we tell you what the rule's about, you have an opportunity, you have 5 minutes, you can come up and say something, and you can submit some documents. Well, what are people going to say? We don't want this here, right? We live here, this is bad for us. Well, how influential is that going to be in agency decision-making? That sort of a statement. Compared to, on the other side, the stacks of studies and analysis and slightly veiled legal threats if you do anything we don't like. How much is that going to influence that decision making? Well, not very much, the community's participation. And so there really has to be a change, a recognition by the agency about the significance of their role when it comes to protecting communities, and a change in the way they approach both the implementation of their programs and the enforcement of their programs. Now, why isn't that happening? So I know I only get 3 minutes, and I could go on for an hour and a half. But why isn't that happening? Well, one of the reasons that isn't happening is you look at the history of these programs. When were our major domestic environmental programs adopted? Primarily in the 1970, early 1970s, right? Nobody was thinking about environmental justice in a broad sense at that point, right? So as the agencies were beginning, well, how are we going to do this? How are we going to interpret all this? I don't know how many have read the Clean Air Act, right? It's not entirely clear at every step of the way, right? How are we going to interpret it? I think it's totally clear. Yes. Right. How are we going to interpret all this ambiguity and then implement a program? Well, they went through what was then the normal process. We think about it. We talk to the regulated industry, and we talk to the states who have an economic stake in how things are regulated. And we'll come up with a framework for how we're going to do this. And we'll interpret these ambiguities in a way that seems to make sense in the context of the conversation we're having with who we view as the stakeholders at this point. Well, not surprisingly, the stakeholders did not include communities, right? Then what happened, of course, is once an agency has a way of doing something, guess what it doesn't like to do? It doesn't like to change. Change is hard, change is difficult, change is confusing. And so many of the reasons why we have problems in administration of our programs, even when you have an administration that comes in, and I think the Obama administration has been fairly good on these, trying to push things in generally the right direction. That certainly was my experience at DOJ. It's difficult because you have a real calcified approach to policymaking and to implementation. And trying to change that is difficult. And guess what? The weight on the scale from the other side hasn't gone away. I mean, over the last 15, 20 years, they've only become more sophisticated and more better able to do that. Now, I think there's a follow-up question, which is, well, boy, we've got these big environmental nonprofits and people who are involved in these issues all the time. Why don't we hear the conversation happening there? Well, we'll come back to that. I'll stop there,
Yeah.
and I'll get to that in a later section.
Yeah, but let's pick up on this theme of the mechanisms for involving the community. And we've already heard that there may be, that even if those mechanisms exist, it may be difficult for communities to really have a voice. But I want to come back to Sue, because I think in an article that you had written had offered, I think, a different, slightly different perspective, and one that I think challenges the notion that mandatory community outreach is necessarily a good thing, and that it, in fact, could, well, that it could, yeah, let me just actually read. Let me not try to misquote. Let me
That wasn't
actually read let me try not to misquote, but let me just read this. I think it's very interesting. The early response to EPA's interim guidance is a case in point. Community groups applauded the agency for setting up procedures requiring agency outreach and formal response to community groups when thinking about and ultimately finalizing a rule. Businesses responded with concern that mandatory outreach to community groups alone denies businesses its equal opportunity to provide perspectives on regulations directly impacting operations. So could you elaborate on that perspective?
The
And I'm
phrase,
sorry if I misphrased
you did, because it's totally different.
Okay.
Equal is what I'm talking about. And this is really interesting, Patrice, and I got to go back and respond to you here. I will be the last person to deny that there are some business sectors and even some companies within business sectors who are enormously influential and who are resistant to improvements and in environmental protection and to engagement with the community and respect for community perspectives. But I don't think that they are the preponderance. And I also think you're being a little rough on EPA. I have to say, I work with these guys all of the time because I see a very quiet but very profound effort to make sure that the community perspectives must be known and incorporated into every agency action. I'm not going to say this is uniform in the states where there's implementation, but I see a very concerted and very effective effort. And one of the best things they've done, and it won't be popular here because it means I think that geographers are really great and more effective than lawyers sometimes. They put information up on the web that empowers every single community to become very sophisticated in terms of their ability to show, look at this, here's a map. Why is it that this community of color or low-income community has all of these sources of potential pollution, and I look throughout the state and I see the concentration is here? Doesn't that mean that you have to approach regulation, enforcement, and a permit very differently? And that's really profound. I've seen it make a huge difference in terms of permit conditions in individual sites. Nobody really knows it. It's not a very glamorous story, but I do think that the power of information is really underestimated, and that EPA has done, kind of heroic things in terms of making the information communities need to be powerful available to them, free and ready to use.
But Sue, how might you respond to Patrice's comment about, that on the one side, businesses may actually be able to engage with the regulatory process in a way with great counsel, with a lot of documents, and in some ways, I'm just very interested in this idea of mandatory community outreach disadvantages business. Could you just speak a little bit more about that?
I think it ought to be mandatory. It ought to be mandatory to outreach to everybody. Okay. What I objected to there was to say that the proposal was that EPA would have a series of meetings and only representatives of the community would be invited. And there was no reference to the fact that business could in fact submit comments on their own. There's always the assumption we're so powerful, but EPA works very hard, I believe, to make sure that in every significant regulatory proposal, they have specific outreach to community members. And I also think we underestimate the power of some of the very prominent environmental justice and environmental groups lately who really get EPA's attention. And they submit one set of comments and it overrides 150 comments from business if what they're saying makes sense. And I think in fairness, we should reflect that.
Other folks want to jump in on this?
Sure, I'd really like to go back to the point that Patrice was making about money. You know, you can have all the process in the world, and if one side has billions of dollars to spend on preparing and presenting their case, and another side has thousands to spend, that makes a difference. And I mean, this is one of the things that was most stark to me in the last year is that I was hopeful that I was going to be arguing a case in front of the Massachusetts Supreme Judicial Court and my case settled. But another case that was framed around environmental justice and whether or not a state agency had to consider the state's environmental justice policies when rendering a decision about an energy facility did get heard on the day that I was supposed to be arguing and didn't get to. And the lawyer for the company, who is someone who I respect very much and who has been a mentor to me in some other areas of practice, stood up in front of the court and actually said, we paid our experts millions of dollars to develop these studies and these analyses, and they had someone provide their studies pro bono, and ours should mean more. And I think he, you know, it must have been one of those moments that you wish you could take back. But it certainly is something that I think is an undercurrent that flows through a lot of these issues. And to get back to what Patrice was talking about with money, I mean, there are powerful environmental nonprofits. And in 1990, I guess it was, the folks who were leading the environmental justice movement wrote a letter to the Big Ten environmental nonprofits saying, you're ignoring us and you're leaving us out of your work. And although there has been a movement among the funders who fund the work that I do and that NRDC and other people do, environmental justice has remained one of those areas that people don't consider, in the lingo, sexy work to fund. And that's really difficult to get around because, as I said, I work in the Clean Energy and Climate Change program. And funders often, climate change is one of the big issues right now, right? Funders are falling all over themselves to fund climate change issues, especially policy work, and to some extent litigation. But when you start talking about going into communities and representing people who aren't normally out front talking about these issues, don't necessarily speak in the same way or in the same tone that people are expected to speak when they get up and speak to an administrator, people start to back off in terms of being willing to fund those types of projects. And so I'm lucky when I get to engage an expert witness, and I do what I can with the budget that I have, but every time that I go into a battle against, you know, Dominion Energy is one of the companies that I've filed Clean Air Act citizen suits against. It had $42 billion in profit alone. I think our entire operating budget is something like $7 million, which is still a lot of money when you think about the communities who often don't necessarily have access to a group like CLF or a group like NRDC. So that's what we're talking about here, is the fact that a lot of the regulators, and I don't say this to denigrate the folks who work in the role of regulator, But a lot of regulators see themselves as the person who's the neutral arbiter. And it's an adversarial system, which we're all used to because we're lawyers. And so the industry pushes as hard as they can in this direction, and the environmentalists and the folks who are allied with them push as hard as they can in this direction. And you're providing, essentially, this is the lingo that's used, you're providing political cover for the agency by pushing back, and that way when they come down in the middle, they feel like they've got the record they need to make that reasoned decision. Well, that's not the way it should work. The administrators, the regulators are there to implement the law. It took us 20 years to get the regulations put in place from the 1990 Clean Air Act amendments to regulate mercury and those hazardous pollutants that Patrice was talking about, because of all the fights that went on around that. And so one of the things that's really difficult to sit back and watch as someone who's really familiar with the system is this idea that the regulator has got to kind of play the middle here, and they just have to come out in the middle of whoever's pushing the hardest. Because when you think about the resources that are behind those two sides, it's pretty easy to see who's going to win.
Great, so we've got a handful of, about 5 minutes before we open it up to questions. So I want to I know, Patrice, you must be eager to respond to some of these things. And then I want to come back to the question of participation and language access. And then we will be turning it over to you to engage with us. So,
Yeah. So I'd like to make a couple of quick points. One, EPA's made some significant progress on environmental justice. It's all, in my view, I left EPA in 2005. Most of that progress is very new. That is things like EJ View, which is the database that Sue was talking about, which provides the public with the ability to go in and do demographic analysis around facilities, and the ECHO database, which allows the public to go in and look at enforcement and compliance history in a geography-based format. Very, very useful to empower communities and empower advocates to be able to go in and be more effective in their advocacy. And the agency has been taking much more seriously in the last several years issues around environmental justice. That is, if issues come up and they're raised with enough specificity and raised and articulated in a way that makes sense and are somehow connected to the statutory program, they're much more likely now to give credence to that rather than to find some excuse to ignore it, which was, frankly, in my view, historically what they would attempt to do. There are a couple of things that I want to add to Shanna's observation about the asymmetric relationship, and it is really asymmetric between communities and industry. One is the involvement of industry in policy-making process happens way, way before the public proceedings occur, right? They are showing up in EPA's offices from the very moment that EPA says, we're going to start working on this rule. They're getting appointments, they're talking, they're submitting material. That conversation is happening all the time. And it's not just EPA, right? They're going over to the White House, to OMB, and they're saying, hey, you guys, EPA is working on this rule. When you get to see it, make sure they don't do anything. And I will say there are a number of quite good industry groups, and Waste Management certainly is among the very best in terms of being good citizens.
Throw me a bone.
No, it's true. But I will say where I've run into the most resistance and the most trouble is with the industry associations, which have less accountability as individual corporations, right? Because they're not an individual corporation that you can go to and say, you're a bad actor. They're an association. And they can just say, oh, we have hundreds of members and we represent everyone's interests, so we might be saying this, but you can't associate this with any particular member. Right? And so it's not just the individual. It tends to be the individual companies and that relationship is still asymmetric when you get down to the licensing stage. The individual facility, the state agency going through the procedure to license or relicense or whatever. When you're talking about big environmental policy decisions that are being made by EPA, right? A new rule under Section 112 of the Clean Air Act. Then you're talking about some businesses will jump in, but then the associations jump in, really get involved. And then you tend to see more and more sophisticated advocacy on the part of the public, including increasingly these days advocacy aimed at environmental justice concerns. Still not adequate, in my view, and I've participated in a number of these. Still, you know, the environmental NGOs are just beginning to figure out how to do this, and I will talk a little bit more about this in response to one of the other questions, but it's not entirely effective yet. And I would say, if anything, getting to this question of, you know, should the agency be actively saying, yes, there's an obligation to go and engage communities, I'd go further. I'd say we ought to have a public advocate whose job it is to provide that sophisticated advocacy on behalf of community-based interests, right? Many, if you go to the state level and you look at public utility commissions, many public utilities states have a public advocate in their public utility commission process. That is, your job is to advocate on behalf of the interested public that doesn't have the capacity to advocate effectively on its own. So I'd go even further and say that there ought to be more protection for those who are most vulnerable and least able to influence the process and most affected from the outcomes of those decisions.
Okay, and before we open it up, last word to Daria to talk about some of the challenges to even engaging with the process.
Yeah, and just to kind of build on what Patrice was saying, I mean, I like the idea of having a public advocate, and I was thinking, you know, this conversation is so important because it's the people who are making that decision to issue the rule or drafting the rule who need to be thinking about environmental justice and the impacts on communities. So even if there isn't a public advocate, is that person who is beginning to do the drafting thinking about environmental justice issues? Because part of engagement, public engagement, community engagement, requires that engagement be meaningful. And if that engagement doesn't come until the rule's already been drafted and you've had 20, 30, however many people or organizations involved in the process, how meaningful is that involvement? How meaningful is that engagement? So, you know, to the extent that we're able to advance the conversation on environmental justice, getting people to understand impacts on communities, disparate impacts on communities. So when we're shaping climate change, climate justice policy, what does that mean not just for the broader goals of addressing carbon pollutants, but what does it mean for a community that may have 5 petrochemical facilities outside of its door in Beaumont, Texas, or people who live in Cancer Alley in Louisiana, between Baton Rouge and New Orleans. When you think about cap and trade policy, does that make sense on a bigger scale? What does it mean for the people who have facilities that may be not capping, who will be buying credits in order to pollute? So that engagement has to be meaningful and meaningful for everybody. Sharmila mentioned language access. There's communities all over this country who do not have English as their primary language, do not speak English well enough to effectively engage, but have every right to be protected under our laws. And so where there are engagement opportunities, where there are efforts to get input from the public, there has to be an assurance that LEP, limited English proficient communities, are able to fully engage and fully participate, and the law requires that as well. I can add more based on questions that come out, but I'll just conclude.
Great, thank you. So, I mean, a really important conversation that's happening here. Let's get you involved. Let's do it this. Let's take a few questions, and I think microphones are going around. Is that right? Yeah. So let's take a few questions, and then we'll give the panelists a chance to respond. So we'll start up here. And if you don't mind, just introduce yourself when you speak. Thank you.
Hi, I'm Scott. I'm a law student. And I think this question is best directed towards Shannon and Patrice. I want to focus in on one particular issue. It comes up in environmental justice, and that's proving individual cases of individual causation, health effects, causative effects. What issues have you How has that impacted your work in particular, Shannon and Patrice? And what improvements do you think need to take place connecting? I've worked particularly on nuclear weapons issues and people proving health impacts from that industry. So how has that impacted your work, and what improvements do you think people should pursue to try to address some of the problems that get raised around environmental justice in particular?
Great, thank you. Let's go, I saw a hand back there. Yeah. Right in front of you. Oh.
Hi, my name is Deanna Nelson. I'm from Northern New York. I'm interested in anyone on the panel can answer the question. In New York, we're having a lot of battles over the consumptive use of groundwater, clean drinking water, whether it's consumptive use through hydrofracking and the chemical contamination of groundwater, or the commercial extraction of water for sale elsewhere in the region. And there seems to be an incredible dearth of understanding as to the quantity and quality of the resource and who's using it and what theories of water consumption use. It seems to me mostly riparian, really, except in larger cities where there's privatized water sources. To what extent is there any policy work being done on this area? Because it seems to be very few tools for these communities to fight back in terms of protecting or having an intelligent discussion about the resource and who needs it, particularly in rural areas and lower economic areas where people are dependent upon groundwater itself for their sole source of water use. Thank you.
Great, thank you. We'll come up here, and then we'll take it back to the panelists.
Oh, thank you. Michael Horan, New England Law. Thank you for all the work you do in the New England area, CLF. In keeping with your theme of participation, you've talked about two different constituencies a lot, the brilliant legal community and the perhaps less than knowledgeable local communities. My concern is with a third, the, let's say, somewhat more militant environmental wing. I wound up in law school in part because of my work with 350.org, et cetera. And when I got there, I found out that none of my environmentally minded colleagues really knew anything about 350.org. Conversely, I was at Brayton Point when 40 of my friends were arrested, and I found that they knew nothing about the work that you guys were doing at CLF around Brayton Point. And I'm wondering, it frustrates me sometimes because I feel like I have a foot in both camps, and I'm wondering if you see any way that these two different groups can lend some sort of mutual aid and support. And I think of this particularly in terms of all that might go down if Keystone gets green-lighted. Thank you.
Thank you, and we'll take the final question up here.
Hi. I was curious, you've talked a little bit about the relationship and intersection between business and the community at sort of the macro level, but I was curious, it seems like if people are working in the plants that you were mentioning before, that there might be some intersection also between the community itself and the people, being the same people that are working in those plants. So I was curious if you could talk a little bit about how that plays out for advocacy in the environmental justice realm.
Great, thanks. So 4 great questions. I think we'll start, Shanna, with you.
Sure.
And then we'll move down the panel.
Yeah, so I'll start with the first question. It seems like Patrice will probably also have a lot to say about that. The first thing that I think you need to be careful to avoid, especially when you're prosecuting a citizen suit under one of the major environmental statutes, is taking the bait from a defendant who's claiming that you have to show direct causation between the people that you're representing and the harm that you're talking about. Because what's at issue in that case is standing. It's not proximate cause. And standing is very different, but there has been a move by a lot of defendants recently to try to force people to say, can you tell me that on the same date that there was an opacity excursion from the plant that you're suing for opacity violations, that you had an asthma attack as a result of that? That's not what standing is. And I think a lot of smart lawyers are trying to turn standing into a demonstration that is not required under Article 3, and that's something that I think as members of ACS, we all need to be very focused on keeping that from happening. And there's a great article written by, in full disclosure, she was one of my law professors, but Elizabeth McGill, who I think now is out at Stanford Law School, on kind of the evolution of standing. And during the civil rights era, standing was being expanded to some degree, and during the beginning of the environmental rights movement, standing was also being expanded, and some of the best cases that we had there, Lujan and some of the Sierra Club cases, really the big pieces around those were associational standing, so that groups like mine can sue on behalf of their members, and also the idea that recreational and aesthetic interests and reasonable concern for your health based on violations of the existing standards that are established by these environmental statutes is enough to show standing. So one of the things that I see is really important over the next few years is that we take some time to develop a really good counterattack to these attempts to turn standing into something that it's not.
Yeah, those are excellent points, and in most instances, in that sort of either in the instance of violations and pursuing violations under citizen suits, or in the instance of pursuing a review, a challenge to an EPA rulemaking, for example, or an agency rulemaking of some kind, you shouldn't have to show that kind of causation. Now, where I think the questions, I mean, there's another place where these issues come up, and that is with respect to the scientific data upon which agencies rely when they're establishing that framework in the first place, right? How much of this pollutant is too much, right? So you take something, we'll go back to the conversation of the hazardous air pollutant program, right, which was broken from the very beginning and took 20 years for advocates to get the courts to fix it, essentially. And it's mostly fixed, not entirely fixed. One of the questions is, well, how much of this pollutant is okay? And if part of the agency's obligation in looking at setting standards for emissions that are going to affect communities is at what level are these emissions considered safe? And there's some language in the Act. I won't go into the details of it, but it's this idea of adequate margin of safety, right? That ends up being a really important part of that policy advocacy, and there are a number of things that the agency has typically not done that I think particularly disbenefit environmental justice communities, poor communities, and communities of color where there tend to be a concentration of air pollutant sources, and that is look at a combination of different pollutants that community suffers from, right? So that community may be surrounded by 25, and I filed a brief recently in a case and looking at a community just on the eastern side of Houston. There were, just the types of pollutants we were looking at, which was chromium pollutants, not good stuff, right? And there were more than 50 different sources contributing. And 30 of them were in the database that were part of this rulemaking. But if you step back and say, well, what other hazardous air pollutant sources are in this sort of geographic region? Well, there's another 260, 270, right? So all of these pollutants are contributing to the health or the adverse health of people in the community. And the agency has never quite got its head around how to consider those sorts of multiple pollutants, multiple contributions, especially when they're contributions of different types of hazardous pollutants. Well, how do they interact with one another? What kind of synergistic effects do they have? How do you account for that sort of concentration of multiple pollutants from multiple sources? That's been something that's been really problematic, and the agency is in the process now of going through a rulemaking proceeding to try to figure out, well, what do we do about these sorts of things? So it's a really important question, and it comes up in different contexts.
Okay, great. So maybe we'll come, if you have thoughts on another question, we'll come back to you. Let's pick up maybe perhaps one of the other questions that got asked, Sue.
Yeah, I'd actually like to comment on two questions, the one on water and the one on workers, as going back to my theme of information and the way in which it improves decision making. Most companies have policies with regard to hiring locally and having the people that work in your facility live in the community. And it's critically important so that they understand what people are thinking. You get honest conversations within the family. And when you go to church, when you go to the boys' club, and you find out concerns about the facility that you need to address by that kind of link. And I think that's why we really are quite firm in terms of a path to promotion means that you commit yourself to the community, you engage, and you're expected to be active in the schools and know what the concerns about the facility might be, as well as what the opportunities are to be helpful. On water, I am not a water expert, but one thing I do is our sustainability disclosure. And we haven't talked at all about the power of NGOs to establish expectations for socially responsible business that drive behavior beyond regulations. And the Carbon Disclosure Project is a classic case in point, because they expect you, and we get all of these letters asking us to respond from our customers to say where you get your water, what you're doing with it. And it's just beginning, and a lot of companies aren't doing it yet, but it really does make you think, and it makes you think, what am I doing to minimize the amount I'm taking? And you disclose what you're in fact using. I don't know if it's that helpful in the local area. I do think that that's a need that government has to supply better than it does. But I did think we ought to mention just some of these activities that are powerful sources of information, because you can look at the reports, and if there are people who are not disclosing what they're doing, that's a good advocacy avenue as well.
I think I can probably speak most directly to your question about labor and workers. And really what came to my mind at first was looking at agricultural workers and people who work in our food processing plants and those conditions where they often don't have a voice to be able to speak about the conditions in the workplace, either because laws like the Occupational Safety and Health Act may not cover the issues that they're addressing, or they may not be able to communicate effectively. I think a recent success or positive outcome at EPA related to a complaint that they received related to migrant farm workers in Louisiana who, you're working in outside and there are pesticides that are being sprayed, and there have been cases where pesticides are sprayed on people while they're working in and outdoors, and there wasn't a process available for them to effectively complain about those conditions and those exposures. And because the process essentially, because they were migrant farm workers, the process required them to submit their complaint in person, but by the time they were ready to submit their complaint, or do an in-person interview, excuse me. So once their complaint got processed and the in-person interview was required, they had left the country. And so the company, the organizations were able to continue with these same practices without really having to respond to these concerns. An organization in Louisiana filed a complaint on behalf of these workers, and EPA was able to reach a settlement agreement with the Louisiana Department of Agriculture and Forestry to improve access to that complaint process for those workers in particular, to ensure that they could either do it by phone or that there were interpreters available, or documents would be translated into Spanish, which was the predominant language. But again, it comes to I think local nonprofit organizations being able to work with people in the community to try to advocate on their behalf. The complaint, like I said, was filed by an organization. It wasn't filed by any individual worker. So there's that relationship that I think is really important as well in order to advocate on behalf of workers and people who may not recognize that they have rights that need to be protected.
Yeah, I want to make observations on two of the questions. The first, again, is the issue of labor and the relationship between the community and businesses in the employment relationship. And I think Sue makes a good observation that in the best of circumstances, what you have is an industry participant who's committed to being a part of that community and being a part of that neighborhood and listening and caring and viewing themselves as as part of the livelihood of this community, right? And that happens. But there's a difficult dynamic here, right? Because as an employee of, and so let's say, let's look at not so rosy of a picture perhaps, right? So as an employee of an industry that's located in your community, you have some interests that are maybe inherently in tension with one another, right? You have a financial interest in continuing to be able to show up and have a job and get paid and support your family. And you have an interest in your family not being poisoned. And to some degree, there may be tension between those two interests, right? And it's not a very good position if you think about it personally, and certainly if you think about it as someone who's a parent, which I am, it's not a very good position to be in. And one of the things that I've seen emerge out of that dynamic is employers who tell their employees, here's what's going on. If you speak up in opposition to what we're trying to do, whether it's a permit or some new something, you're going to lose your job, right? You may not have a job left. Then the position that puts that person in terms of the tension is fairly untenable, or it's very difficult. It may be, there may be some validity to that in some instances, that there's a real tension. You can't, we sacrifice certain things for the way that we live. That's true. But that is definitely abused, and I have seen that abuse go to some fairly extraordinary extremes. So much so that there's been some cases that I've been involved in that where the company has literally not just said, you may lose your job, but we will fire you if we see you anywhere around this. And, right, we are going to send our people out to intimidate you, like physically intimidate you. If you show up, we're going to have people standing in front of the venue threatening you, acting threateningly towards you. And actively telling you, you better not participate, you're in trouble, and your brother works for so-and-so and they'll get fired. I mean, that's sort of over-the-top sort of stuff. So I want to see that partnership of business and the community, but the business is in a position of disproportionate power in that relationship. And so the responsibility really is on the business to be a good partner.
Let me just
Yes.
give
Yeah.
Sue a
Yeah,
chance
I
to-
agree completely, and corporate governance geeks pay a lot of attention to whether or not companies have a system to deal with that, because I agree with you completely. It's a huge problem, which is why best practice is to have an anonymous hotline run by a third party where in fact the employee can jump through channels, not talk to the boss, and get a resolution. And you have the legal department monitoring to make sure that there is a response and there's no potential for any retaliation against an employee that raises an issue. And in fact, once a year, we all have to go through the code of conduct and do a written affirmation that we are not aware of any violations that the company is participating in, that we have failed to come forward to the general counsel. And that's a really good thing. But nobody pays attention to this sort of thing. And so it doesn't become an expectation. It's not regulatory, but it would help a bit.
Yeah, I think it's one of the illustrations about why the agency that's undertaking that responsibility to do the permitting, to do the rulemaking, to do whatever it is that's really needs to view themselves as there on behalf, at least in part of, they have a mission that's driven by the statute, and it ought to be driven by the statute, but it ought to, a part of that ought to be to ensure that the types of issues that are going to be important to communities become a part of that decision-making process, because there will be dynamics where people who are part of that community may not feel that either they're able to or that they can, without threat to their livelihood, participate on their own. I wanted to respond to the gentleman here who was talking about 350.org and some of the other more I forget your language, but the more strident advocates. I mean, I guess I would say I think that's a really important issue. And I think one of the things that has emerged over the years is that advocates have become very siloed. They sort of operate within this echo chamber of here's what we do, and we both guard it very closely, and we don't and we don't go looking for viewpoints to incorporate into our advocacy that are beyond this sort of this silo that we've been working in for a very long time. And you know, I'm not sure what the answer is in terms to how to get around that. I do think that one of the things that will be helpful, and hopefully we'll get a chance to talk about this, is enhancing the diversity within those organizations. And I want to talk more specifically about that. But also,
5 minutes left in our whole panel.
in our whole panel, okay. So why don't I talk something about that?
Why don't you talk? Yeah, I was going to give you 30 seconds to end, so maybe yeah.
Can I address the specific question he's talking about,
Yeah.
the Brayton point and 350, and then I'll let you. It'll lead into I think
Please.
what you're probably
Please,
going to
yeah.
talk about on a more general level. So, so we had been working on for about 7 years since 2006. Well, actually, since the late 90s, on cleaning up coal plants and shutting down coal plants in New England and Massachusetts. And we'd actually talked with a lot of the folks who were engaged at the leadership level of 350.org. And very few of those people actually lived in or anywhere near Somerset, Massachusetts. We had been engaged with individuals who lived in that community for 6 years, and they were very concerned about someone coming in and doing an act of civil disobedience and the physical threat that they felt in being associated with someone who was doing that. And so there was a lot of discussion among the leadership of 350.org and CLF and the Toxics Action Center, who'd been working with the residents of the community about the concerns that the locals had about that, because in some respects, 350.org it's an international organization, but it's also got smaller local groups that are part of that. I really appreciate that people care so much and care so deeply about the issues and are willing to go on and take up civil disobedience. From my perspective, as someone who works at CLF, I am focused on trying to do what I can within the legal realm. And so it would be, since I'm not able to go and participate in those civil disobedience events, it would be, to my mind, hypocritical for me to say, yes, you should go commit civil disobedience, but I'm not going to go with you. At the same time, what we were dealing with there was a really strong group of local residents who had been working on this issue for years and felt a little bit like these people were coming in from outside and protesting at the plant that's in their backyard, and they were going to end up being associated with that and be the people who were going to have people come to their house and knock on their door and say, why are you doing this? So that was a very tense issue, and it's one where I think communication is really important, and one where it's very important to look at the people who are most vulnerable, the people who live in those communities and are dealing with those issues. So.
Great. So we have just a couple of minutes left in our panel, so we'll give folks maybe 30 seconds to a minute left to just kind of offer some closing remarks. And I know this is a big topic. It's been alluded to.
All right, I will.
And you can talk to him in the hallway afterwards.
That's right. I'll talk really quickly. But I was like, one of the other things that I think is absolutely critical for environmental justice generally, but certainly around, both around policymaking on the government side, both federal and state, but also on the advocacy side, is diversity. I mean, if you look, I was recently at a national NGO environment event, very large, big room, hundreds of people, and you looked around, it looked an awful lot like the Republican caucus. And that's troubling, right? It's troubling because the work that we do, and full disclosure, I sit on the board of Earth Justice. The work that we do affects everybody, and it affects, in many instances, the communities that are closest to some of the facilities, the discharge points of pollutants most profoundly. And we need that dialogue to include experiences and voices and skills that come from a much broader range of people, that look much more like the constituency that we ultimately represent, whether we want to or not, right? We're representing everyone because we're doing this work. And I think part of what comes along with that is a better ability to communicate with communities, with other groups that maybe have different viewpoints and different approaches to things, and a breaking down of some of that silo, some of that echo chamber that has emerged over the decades as we've been doing this work, both on the advocacy side and on the policy making side, so that we start thinking more creatively. I mean, certainly business is way ahead of us in doing that.
And that's a nice tee up to let Sue.
Oh, it's nice that you said it, because I was going to say, you know, business has the same problem. There are all kinds of studies about the representation in terms of women, people of color, particularly in senior leadership. And I would say, I'm not going to name the company, but recently we saw a woman take the helm of a company, and she seemed to be taking a position that showed she was more responsive to the human impact of what her industry does. And I just think you said it so beautifully. You're just leaving all of that intelligence and your ability to be competitive on the table if you don't increase diversity throughout the organization.
I absolutely agree, and I'll kind of pull from, I teach a class in environmental justice at Howard, and I co-teach it with several attorneys, and one thing that we always say to the students is, you know, we don't care where you're going to go work, but we want you to work with an environmental justice mindset, to think about how your work impacts the most vulnerable communities. So whether you're in business, whether you're at a nonprofit organization, whether you're in government, that you have the ability to look at the impacts of your work on people who may not be able to have a voice at the table, who may not even be able to get to the table, who may not even exist yet, frankly. And so to think about that and be sensitive when you're shaping policy, when you are advocating on behalf of certain communities or any community, how is this going to affect not just the broad picture, but people who are most sensitive and most vulnerable?
Great. And so with that, I think that this was a really remarkable conversation that gave us an opportunity to reflect on the 20th anniversary of the Environmental Justice Executive Order, 50th anniversary of the Civil Rights Act, and some really interesting themes going from the community and participation to the Byzantine world of environmental law that picks up actually with property rights. We can talk a little bit more about water perhaps offline. But thinking about the roles of data and transparency and trying to go beyond what the law requires to being a good corporate citizen, and thinking about the way in which civil rights laws really do offer a vehicle through which we can try to tackle these problems. So with that, thank you very much for joining us. I hope